instructions that are to be followed during the. Firstly, do not unmute your mic during the session. Secondly, you can mute your mic and ask question during the question and answer round. But if the speaker asks you to question him during the session, so you can ask question during the session as well. But it's totally upon the discretion of the speaker whether they allow you to ask questions in between or not. And you all have to switch on your cameras and they have to be on during the entire session. I hope you will follow the instructions and switch on your cameras.
Hello everyone. Am I audible to all of you?
Yes, sir.
Brilliant. Good evening. How are you?
So we can start?
Shall we start?
Okay.
Okay. I'm asking you. It was a question. It wasn't a
I was asking you that.
All right. Let's wait for a minute or two, and then we can start. I don't know how many people. There might be people who might be still joining in. I see a huge crowd here. Makes me so happy. Are most of you students or many of you young lawyers? Is there any idea?
So most of them are students.
That's it. And from a particular college or university?
So they are from all over India.
All right. Such a pleasure. Good evening, everyone. I think I'll start. Shall I, Rupam? Rupam, shall I start?
Yes, sir. Anika, please start with the introduction. Over to you.
Okay. Thank you. So, good evening, everyone. This is Anika Sharma. I'll be your moderator for today's session. And on behalf of Amicus Curiae, I welcome you all to this guest lecture on aviation liability and domestic implementation of air safety and security regulations in India. So, this is organized by Amicus Curiae, and Amicus Curiae is the brainchild of several legal luminaries and eminent personality across the country and the globe. The TAQ is a dream online platform which aims at proliferating legal knowledge and providing an ingenious understanding in cognizance of various fields of law to make sure that legal knowledge and experience penetrates to every nook and corner of the ever-growing legal fraternity. Through ambitious and studious legal brains across the country, Amicus Curiae aims at providing valuable contributions to contemporary legal issues and developments in the omnipresent field of law. The Amicus Curiae is also a registered organization under the Indian Partnership Act 1932 and Ministry of MSME, Government of India recognized organization and an ISO certified organization. Today we have Mr. Kapil Sankhala to enlighten us on the topic of air safety, security regulations, and their implementation in India. He is the founding and managing partner of Sankhala and Associates, an advocate at Supreme Court of India. He has been in practice since 1999 and has been awarded the coveted Super Law of the Year 2016. His experience covers a broad range of areas relating to dispute advisory, litigation and arbitration, corporate and commercial matters, white-collar crimes, employment, infrastructure, and aspects of public policy and administration, governance and ethics. He has been listed as one of the leading lawyers in India in various publications from time to time. He has been empaneled counsel for various government departments and major representative clients including DDA, DSIDC, BJP, Bucks Board, Chandigarh, Life Insurance Corporations, and many more. And now there is a list that goes on for all his achievements and all his experience that he has done in his long career. And now I would like Sir to take over and continue with the session.
Thank you. Thank you for this very kind and generous introduction. Thank you, Amicus Curiae, for this wonderful opportunity. I think it is the second time that I've been invited by your wonderful organization, if I'm not wrong.
It's the
Yes.
fourth time, sir.
Fourth time. Oh, I'm so sorry. I am so sorry.
Yes.
So this is what the world has happened. The digital world is shrinking and becoming smaller. But now I am extremely pleased. I must be doing something right. Thank you once again. And I'm so very happy to see such young, bright, talented minds in this legal fraternity. All of you getting together to ensure that the knowledge and experience gathered by many of us, not by intellect necessarily, but mostly by simply offering our time and energy and years to the profession, is being passed on. I truly believe that while this lockdown, this pandemic has taken away so much from us, from our loved ones, independence, acquaintances, our place in the sun, and many practicing lawyers, and you all will also know our daily bread, our daily earnings, I truly believe that there is a silver lining such as this. That many of you have got together to create these marvelous avenues of networking, of sharing knowledge, creating avenues of learning. Commendable. I commend all of you. Many of you know me as a lawyer who's on the criminal side, but not many of you know that Saftey and Associates have represented some of the best and top aviation companies, all the way from various unknown ones to the known ones like MPLR and SpiceJet. And I'll tell you this before we talk about this topic, that from litigation all over India, handling disputes in UK, we proudly represented our clients. This topic is vast, but today in this 1 hour, I'll encapsulate a broad view, overview of the civil aviation laws with emphasis on laws of liability. And I will also briefly discuss international laws because those are the ones that's changed the way the Indian laws are and is further evolving Indian laws. Remind me if I forget to talk about how Indian laws will now further evolve when we talk about drones coming in the airspace. For those of you who hope to create a name for yourself in the aviation sector, know this. I would urge you strongly to deeply understand the laws of drafting of corporate and commercial agreements and also understand consumer laws as much as we have read and prepared ourselves as aviation counsel. We have substantially worked on negotiating dry and wet contracts, and for those of you who already studied aviation laws, you would know what dry and wet contracts are all about. And also worked on Indian and international arbitration and have substantially worked on consumer related issues. You know that consumer laws have had material change now as far as jurisdiction is concerned. And for all you budding aviation lawyers, that's one thing that you would be dealing with now substantially, as the jurisdiction is now based on where the consumer is, widening the scope of litigation all over India. Before we delve deeper into the topic, you will be very proud to know that the aviation industry is, or the aviation market is one of the largest growing market in the world, the Indian aviation market. When you talk about the topic, when you talk about aviation, it's broadly divided into military and civil aviation. And to repeat myself, when you talk about military and civil aviation, you will also now remember the natural progression that would be the airspace being also hijacked by drones, which would have civil aviation, civil and recreational use as well as military use. The topic of the day is very interesting: aviation liability in India and domestic implementation of air safety and security regulations in India. Did you all know that the first commercial aviation flight in India took place in February 1911? We have come very far from there that day. But even after the first commercial aviation flight took place, it took years for any meaningful growth in this sector. In fact, the regular airmail was not established until 2 decades later of 1911 by Mr. J.R.D. Tata, who was awarded a contract to carry mail in 1932, and he used to do that personally for years together, and founded an airline that thereafter was taken over by the government and is now known in its avatar as Air India. From the international Indian perspective, it is very important to know that the Ministry of Civil Aviation is responsible for the civil aviation through regulatory oversight by the Directorate General of the Civil Aviation, which is DGCA. For those budding lawyers who will be working in any aviation company, you will realize that DGCA is your Becca, where you are there at the beck and call. In fact, 40% of our work, which was apart from the consumer work and negotiating contracts when it comes to the airlines or the aircraft that were there, the hardware contract, we were dealing with various issues pertaining to DGCA. Now, the public international aviation law in an aviation context refers to agreements and treaties amongst various nations related to issues such as, for example, landing rights, then overflight authorization, security and registration and communication. You would know that for some time, India had made sure that none of its flights were going through the airspace of Pakistan, and it even stopped the Pakistani airlines to go over our airspace. So these things are very important because these actually materially affect the time, the costing, and the viability of international airlines that fly from one zone to another. The origin of public international aviation law is deeply rooted in the period following the end of World War I. Before and during the war, aircraft were largely viewed and known as military weapons. It was only aftermath of the war that lawyers and judges and politicians and people who handle international laws and relationships all understood and recognized the profound impact that air travel would have in challenging the traditional notions of borders and ownership of airspace. As I just said, that the dispute between India and Pakistan is a case to point. All you have to do is Google it, and you will understand what is the importance of ownership of airspace. Some of the most significant aviation treaties, conventions, and international agreements, and the compacts impact related to public aviation are the most important ones, of course, are the Paris Convention, which was of 1919. Then you have the Havana Convention of 1928. You have the Chicago Convention of 1944, the Open Skies Agreement of 1992. Now, the law relating to air traffic has steadily developed in US and other developed countries right from the time when the first elementary aircraft were introduced in these countries. The International Civil Aviation Organization, ICAO, headquartered in Montreal, was established pursuant to the Convention on International Civil Aviation, which has a membership of 184 states. The exchange of commercial rights in the international airspace is regulated mainly by hundreds of bilateral agreements, along with multilateral international air service transit agreements of 1944, and also certain provisions of the Chicago Convention, also of 1944. Then, of course, you have the Warsaw Convention of 1929, which was subsequently amended by the Hague Protocol of 1935, which is widely accepted and governs the liability of air carrier with respect to international carriage of by air of passengers, baggage, and cargo. We'll stop here for a moment. And this is why I said, please read your consumer laws very, very carefully, because at one stage, you have all these conventions that create national and international liabilities, and then you have consumer tribunals which have somehow entered into this domain and have also created rights in favor of consumers, which are very far reaching, because you also know that the explanation and definition of consumer also has kind of grown over the years and also encompasses various commercial transactions. Now, another important aspect of air law is concerned with the suppression of unlawful seizure of aircraft, the Hague Convention of 1970, offences and certain other acts committed on board of aircraft, which pertains to the Tokyo Convention of 1963, and suppression of unlawful acts against safety of civil aviation, which is the famous Montreal Convention of 1971. Each of these conventions have been accepted by many, many states and therefore have wide-reaching acceptance and implementation. As far as your domestic implementation of air safety and security regulations are concerned in India, India, since its independence, has a long and established precedent for implementing international conventions through specific national laws. As member of International Civil Aviation Organization, the Government of India has implemented several international civil aviation conventions through domestic laws. Some of those are that India follows the ICAO guidelines on safety and standard and recommended practices, which is called SARP, Safety and Standard and Recommended Practices. India has also ratified the Chicago Convention, which is the International Civil Aviation Convention, but has opted not to ratify Article 3, which is civil and state aircraft, and Article 83, which is transfer of certain functions and duties under it. India has been extremely cautious over the years not to let any international organization encroach upon its own rights in its own territory. Now, India has ratified the Convention on Recognition and enforcement of foreign arbitral awards, signed in New York in 1958, which is the New York Convention. UNITRAL is something that you would be reading whenever you do international arbitration, which is extremely important. It talks about seat of arbitration and the law of arbitration and the law governing arbitration and how seat of arbitration shall govern certain aspects of arbitration. India is also a party to the Warsaw Convention of 1929, the Hague Protocol, as I said, of 1955, and the Montreal Convention of 1999, and the provisions provided therein, subject to the provisions of the Carriage by Air Act of 1972, our Act, which have the force of law in India in relation to any carriage by air, irrespective of the nationality of the aircraft performing the carriage. India has not signed the Geneva Convention on International Recognition of Rights in Aircraft of 1948 or the Convention for Unification of Certain Rules relating to precautionary arrest of aircraft of 1966. As per the provisions of ICAO, the states are required to delegate the investigation of the accident which have occurred in their territory. And in compliance of this, the Government of India passed the Aircraft Investigation of Accident and Incidents Rule of 2017 and provided the authority to the Aircraft Accident Investigation Bureau of India to look into the matters relating to any accidents that might occur. And it would be very interesting to know why this came into being in 2017. Just see the number of accidents that took place in the year 2000 and thereabout, and you would know that why India finally woke up to it and created the Aircraft Investigation Accidents and Incidents Rule of 2017. Now, there's certain key legislation governing air transport in India, and for those students who would like to note it down, you may, because this would be probably an integral part of what you might be studying. The key legislations governing Indian air transport in India are the Aircraft Act of 1934, the Airports Economic Regulatory Authority of India Act of 2008, the Airport Authority of India Act of 2003, the Carriage by Air Act of 2016, very important, the Anti-Hijacking Act of 2016, of course, the Aircraft Act of 1934, the Tokyo Convention Act of 1975, as I just said, the Aircraft Investigation of Accidents and Incidents Rule 2012, 2017, in fact, the annexures to the Convention of International Civil Aviation and ICAO procedures adopted with such reservations as may be necessary and brought into force from time to time by notifications, in circulars by AIP India, etc., etc. The earliest legislation in India was enacted in the Indian Airship Act of 1911, intended to regulate the manufacture, possession, use, sale, import, and export of airships. It was presumptuous enactment in those days because barring the Humber flight of 1911 that we just spoke about, there was no regular flying operation in India till the late 20s. Further, the regulation of manufacture of aircraft through this act appeared equally strange and ludicrous because such activity did not commence in India for another 4 decades. Then followed the Aircraft Act of 1934. Now, the Aircraft Act of 1934 and the Aircraft Rules of 1937 are important in the sense that the primary domestic regulation that controls the Indian aviation sector is the Aircraft Act of 1934. Its main purpose is to provide the federal government the authority to create laws governing the manufacturing, the sale, use, operation, export, import, and safety of all civil aircraft. Similarly, the Aircraft Rules of 1937 generally apply to Indian registered aircraft and to persons thereon, wherever they may be. Of course, there are exceptions as in all acts, and all aircraft present in or over India. These rules set requirements for flying conditions, registration, airworthiness, and licenses, amongst other things. Where an aircraft is registered in a foreign country, the regulations of that country will apply, provided that their underlying standards are based on those established by the Chicago Convention. Further, the extent of application usually depends on the agreement between the two countries. Then importantly comes the Carriage by Air Act of 1972. The Act seeks to implement the provisions of the Warsaw Convention relating to international carriage by air, which affixes liability for international carriage of persons, luggage, or goods performed by aircraft for reward. The Act came in force on 15th May 1973. There is no separate statute for domestic air carriage in India. And then, of course, comes the National Aviation Safety Plan of 2018 running up to 2022. The DGCA has released a 5-year National Aviation Safety Plan which promotes and supports the prioritization and continuous improvement of aviation safety in India. The Aircraft Carriage of Dangerous Goods Rule of 2003 regulates air carriage of dangerous goods like explosives, radioactive materials, etc., and also provides for establishment of training programs by or on behalf of shippers of dangerous goods, operators, ground handling agencies, freight forwarders, and agencies involved in the security screening of passengers, their cargo, and their baggage. The Anti-Hijacking Act of 1982 implements the Convention for the Suppression of Unlawful Seizure of Aircraft and provides for punishment for the offences of hijacking. Of course, it also encroaches upon the domain of the penal code, but that's a separate thing because the penal code at that time did not really deal specifically with the offence of hijacking, but dealt with offences against the state. Then comes the Suppression of Unlawful Acts against Civil Safety, against Safety of Civil Aviation, 1982. The Suppression of Unlawful Acts against Safety of Civil Aviation Act 1982, implementation of the above mentioned convention, and provides for the punishment of various offences like committing violence on board of an aircraft in flight, offences at airports, causing destruction or damage to navigation facilities, etc. The objective of the convention is achieved through both these legislations. The Ministry of Civil Aviation administers the Aircraft Act and aircraft rules and various other aviation related legislation. It is responsible for formulation of national policies and programs that control over entities such as DGCA or the Directorate General of Civil Aviation, the Bureau of Civil Aviation and Security or BCAS, the Airport Authority of India, also AAI, and has the authority to enter into air service agreements with other countries. Now, the Directorate General of Civil Aviation or DGCA, it was established under the Ministry of Civil Aviation and is the main regulatory body that supervises civil aviation in India. The functions of DGCA include regulation of air transport services to and from and within India in compliance with the aircraft rules of 1957. The licensing of pilots, aircraft maintenance engineers, monitoring of flight crew standards, registration of civil aircraft and certifying their airworthiness, investigation of minor air incidents, providing technical assistance to courts committees of inquiry appointed by the government, supervision over flying gliding clubs, licensing, safety oversight, surveillance of aerodromes and air carriers. Then is advising the government on matters relating to air transport, including bilateral air service agreements with foreign countries. Then comes the Airport Authority of India or AAI, which was established by the Airport Authority of India Act of 1994, formed by merger of International Airports Authority of India and National Airport Authority through the Airport Authorities Act, which came into existence on 1st of April 1995 with a view to accelerate the integrated development, expansion and modernization of the operation, terminal and cargo facilities at the airports in the country conforming to international standards, and the AAI is entrusted with the task of regulating airports all over India. Then, of course, comes the Bureau of Civil Aviation Security, also called BCAS, which was initially set up as a cell of DGCA in 1978. It served to coordinate, monitor, inspect, and train personnel in civil aviation security matters. The BCAS is the regulator for civil aviation security in India. Currently, its functions include laying down the standards and measures in respect of security of civil flights at international and domestic airports in India and Indian aircraft operators at foreign airports, and standards for pre-embarkation security and anti-sabotage measures in respect to civil flights and ensuring their compliance. The Airport Economic Regulatory Authority, or AERA, was created and regulates tariffs and other aeronautical charges, as well as monitors airports' performance standards. It creates a level playing field and fosters healthy competition amongst all major airports, government-owned, private, public-private partnership-based, private, etc., encourages investment in facilities, regulation of tariffs of aeronautical services, protection of reasonable interests of users, operation of efficient, economic, and viable airports. Now, before we go further and discuss what is aviation liability, I would urge all of you to go back to the knowledge that you have gained in civil law as far as civil law of torts is concerned, to remember what liability is, because it has material bearing on what we are going to discuss. As far as liability for aviation is concerned, or liability in a legal sense is concerned, in international forum, one of the most important judgments is White versus Green, where Justice Robinson of the Supreme Court of Iowa wrote, liability in the general sense is the state or commission or condition of one who is under obligation to do at once or at some future time something which may be enforced by action. It may exist without the right of immediate enforcement. Similarly, in Miller and Lux, Justice Temple wrote, the word liability has always been held to apply to responsibility for torts as well as for breach of contract. And in Mayfield wrote, liability is a broad legal term which is usually held to include every kind of legal obligation, responsibility or duty, certainly all that are measured by money obligations. Liability may arise from contract, express or implied, from a duty imposed by law or by judgment of a court, or as a consequence of tort committed. Now, the types of liability are very important. One is, of course, the legal liability, which is the legal binding obligation to pay debts. Then is the vicarious liability, very important. Responsibility of the superior for the acts of the subordinate. When an agent does something, the principal is liable. In your case, you see the refueling process in airport, etc., would all come under vicarious liability. What if one of the employees makes a mistake and there is a mishap? Who will be liable? Whether it would be the person who was putting in the fuel, whether it would be the person who was governing him, or the company itself. Then, of course, comes the issue of limited liability. Limited liability is responsibility based on investment. Now, a limited liability could also be of you lawyers when you give legal opinions and you say that your liability is limited to the payment that has been made, to the revenue that has been generated, to the legal fees that has been given. It could also be in such case as to the limited liability of shareholders attached to an airport company, which is a legal entity, and the liability is limited by the shareholding of that shareholder. So the profit and loss and liabilities are in proportionate to the share held by that shareholder. Then comes product liability, something that you will be fighting for. It's the responsibility not to sell defective product. And it's a very strange thing, but that is an argument that we have made. It's an argument that you as young lawyers in the aviation sector will also make when an aircraft is standing, cannot fly, and the parts are not received, and they would take time to send the part, and then you would threaten them of product liability, saying that you have already sold me a defective product. This part could not have last X flight miles, etc. Now, for an example, you're talking about aviation products liability, where the contracts can cover engine manufacturing, avionics software products, or such similar businesses. Then is the public liability or civil torts or the law of torts, which focuses on wrong based or duty based or standard of care based liability. These are all torts. The law of torts is growing in India because the right to life or the value of life is growing in India. Importantly, also is the concept of vicarious liability, where generally a person is liable for his own wrongful acts and one does not incur any liability for any acts done by others. In certain cases, however, vicarious liability is the liability of one person for the act done by another person. And that is, you're vicariously liable because you are so well connected. And therefore, the test is this, that in order that the liability of A for the act done by B can arise, it is necessary that there should be a certain kind of relationship between A and B, and the wrongful act should be in a certain way connected with that relationship. I will give you a wonderful example somewhere down my lecture. Then, of course, is strict liability, and there is a lot of confusion between what is strict liability and something else called absolute liability. So listen carefully. There are these situations where a person may be liable for some harm even though he is not negligent in causing the same, or he had no intention to cause that harm. Sometimes he may have even made some positive effort to avert that harm or avert that act or inact. In other words, there could be no fault of his, but he may still be made to be liable, and it is therefore rightly called the no fault liability. The case of no fault liability was held way back in 1868 in Raylands versus Fletcher. Wonderful judgment, read it when you can. The rules that were laid down in Rayland were one, dangerous things, example, aircraft turbine fuel, escape, for example, leakage of fuel causing damage, and non-natural use of land. Instead of farming, you're using it for commercial purposes. There are also certain exceptions to this rule. If it is proved that there was plaintiff's own default, or you may say that there was an act of God, or you may claim that there was a consent of the plaintiff, very important, or there was an act of a third party, or there is a statutory authority that protects. Now, these are certain examples and exceptions when it comes to this liability of strict liability. Now, you will also know about absolute liability. Absolute liability has been dealt in MC Mehta versus Union of India, which was the gas leakage case, where the Supreme Court of India took a very bold decision, holding that it was not bound to follow the 19th century rule of English law, and it could evolve a rule suitable to the social and economic conditions prevailing in India at the present day. It evolved the rule of absolute liability as part of the Indian law in preference to the rule of strict liability. The new rule is not subjected to any of the exceptions under the rule laid down in the Raylands case that we just read. The difference between strict liability and absolute liability is this. Absolute liability is a standard of legal liability found in tort and criminal law of various legal jurisdictions. To be convicted of an ordinary crime in certain jurisdictions, a person may not only have committed criminal action, but also have had a deliberate intention or a guilty mind, also called mens rea. In a crime of strict or absolute liability, a person could be held guilty even if there was no intention to commit a crime. Strict or absolute liability can also arise from inherently dangerous activities or defective products that are likely to result in a harm to another, regardless of protection taken, such as owning a pet poisonous snake. Negligence is not required to be. The difference between strict and absolute liability is whether the defense of mistake of fact, and that's your touchstone, mistake of fact disability, in a crime of absolute liability, which is the Indian interpretation, as I said, from the gas tragedy case, a mistake of fact is not a defense. Aviation and liability. Aircraft crash results in significant property damage, including destruction of aircraft as well as bodily injury and loss of life. Now, this cause of accident, when an aircraft crashes and causes personal injury or death, it is often difficult to determine the exact cause of the accident. You would wonder whether it's the pilot's error, whether the aircraft malfunctioned, whether there was negligence on the part of the owner, whether the pilot was well trained or not, whether the aircraft was being flown in a way it wasn't intended to fly, whether the crew and the passengers were aware of how to act in case of such an emergency. A number of airports, large and small, have had such incidents ranging from minor slips costing few thousands in bodily injury towards substantial damages, etc., etc. And therefore, the airport operator's liability coverage is designed to respond to such incidents and protect the airport owner or operator from associated costs of defense and claims settlement. To talk about the risk exposure that an airport owner or an operator has, you have to remember that the airport has all the legal liability incurred resulting from bodily injury, property damage, and personal injury arising out of the performance of their statutory duties and functions regarding any related aviation operations like maintenance and provisions. Examples would be runway and other airport utilities, taxiways, aircraft parking, etc., etc., security system, etc., firefighting, refueling facilities, hangars, even snow clearing. Now, whether an international, regional, local airport or the airport owner operator has a responsibility to carry insurance coverage, yes, and it has to be appropriate to its operation. Whatever limit is ultimately determined, it should be remembered that while the possibility of major loss may be slight, it is nevertheless real. Now, aircraft failure causes can be broken down into various categories: poor design, poor manufacturing, poor maintenance. Any of the aforesaid factors may cause the failure of any aircraft part to operate, loosening of part due to vibration, lack of crashworthiness, etc., etc. The manufacturer of an aircraft may also be put to fault in several ways. However, for a manufacturer to be liable, the craft must have a design defect or manufacturing defect. This can include manufacturer's failure to warn or inadequate warning about known issues such as incorrect emergency instruction, as well as incorrect manufactured or assembled parts, the inability of parts to respond as expected, while the liability of an operator is in cases the operator must have been proved to be negligent or to have acted in a negligent manner. And this can, of course, include, for example, loss of control, inadequate training, misuse of the aircraft or part of the aircraft, failure to react in a timely manner. decision to fly in a dangerous weather. Now, in such a case, there could be various kind of liabilities in aviation. Aviation liability may be sought for an individual, for a property of on an aircraft, or damage to a property caused by a crash or emergency landing. Now, the assumption of risk is a term referring to the victim's clear understanding of the risk involved in partaking in any activity such as skydiving. Now that there's an assumption of risk that you know what risk you are taking. So, for example, where a client chartered a private jet and was recommended to delay departure due to bad weather, inclement weather, but insisted on taking the risk despite the recommendation, the client may not be able to successfully sue for damages. Now, this is called the doctrine of added peril. There is, of course, certain exceptions. One is the Latent Maxim, which is voluntary non-fit injuria, which is a defense of limited application in tort law. A direct translation of this is one who volunteers, no harm is done. So if you volunteer for something knowing the dangers, you will not be paid for any damages if you suffer consequences. So the defense of voluntary non-fit injuria requires freely entered and voluntary agreement by the claimant in full knowledge of the circumstances to absolve the defendant of all legal consequences of their actions. There is considerable overlap with the concept of contributory negligence. So therefore, for a defense, these are the requirements. It has to be voluntary, there has to be an agreement, it has to be made in full knowledge of the nature and the extent of risk. And then is res ipsa loquitur, which is the thing speaks for itself, or this is a very, very important part of the tort law, because this deals with circumstantial evidence that the thing is so clear that there could be no other explanation for this act. The principle that allows the plaintiff to meet the burden of proof with what is in effect circumstantial evidence. The plaintiff can create a rebuttable presumption of negligence by the defendant by proving that the harm could not ordinarily have occurred without negligence, that the object that caused the harm was under the defendant's control, and that there are no other plausible explanation. So this is a concept of prima facie case that we keep on arguing. To prove this, the plaintiff must prove three. The incident was a type that does not generally happen without negligence. It was caused by instrumentality solely in the defendant's control. The principal, the plaintiff, did not contribute to the cause. Now, as far as the development of aviation liability regime is concerned, the legal regime of air carrier liability was considered under the Warsaw Convention of 1929, the first recognition of airline industry as we know today. By 1933, it came to be realized that the liability regime requires to be served by a specialized industry sector. The International Union of Marine Insurance then set up Aviation Committee, and by 1934, 8 European insurance companies and pools were formally established, and finally the International Union of Aviation Insurance was born. The aviation liability regime is set out in the international instruments like the Warsaw Convention of 1929, Warsaw Convention as amended by the Hague Protocol of 1955, the Guadalajara Convention of 1961, and the so-called the Montreal Agreement of 1966, Guatemala City Protocol 1971, the Montreal Convention of 1999. The aviation conventions and compensation levels in India are very interesting, because for a long time India confined itself to ratify only two instruments: the Warsaw Convention of 1929, which was signed in 1947, and the 1929 Convention amended by the Hague Protocol in 1973. Based on these instruments, the liability regime in the country was given effect to by the Carriage of Air Act of 1972. With the passage of time, while many countries made amendment to the provisions of the two archaic instruments, India continued with the very old two instruments with respect to identify the liability of the carrier. Finally, on 1st May 2009, India became the 91st country to have ratified the Montreal Convention of 1999, also called MC99, which is a vast improvement in its predecessor and enable realistic compensation. Gives realistic compensation. India is a party to the Warsaw Convention, the Hague Protocol, and the Montreal Convention, which sets out airline liabilities. An airline is liable for damages sustained because of loss, damage, or destruction of any registered luggage or any goods if the damage so sustained took place during the carriage by air. For example, 20,000 was given for each passenger for destruction, loss of damage, or delay with respect to baggage under the Montreal Convention. Passengers usually file complaints under the Consumer Protection Act on the grounds of deficiency of service from cases ranging from delayed flights, loss of baggage, and even death. And that is why I said, for those of you youngsters who plan to get into this domain, really read your consumer laws. Consumer laws have really grown over the years and have now become very consumer centric. Now, there are certain liabilities which have been given under the aircraft rules. One, penalty for contravention of any provisions of the Act, imprisonment for 2 years, fine up to 10 lakh, penalty for dangerous flying, penalty for failure to comply with directions under 5A, which is imprisonment for 2 years, fine up to 1,000, penalty for failure to comply with prohibition or regulation of construction of buildings, planting of trees, which is imprisonment for 2 years, fine 10 lakh. Defenses which are available is neither truly strict nor absolute. This is in fact presumptive liability made slightly stringent by appropriate provisions under the Convention. Now, the types of defenses, of course, that you can. One is the defense of abundant caution, and second is the plea of contributory negligence. Usually, that is not a defense, but it can be. Then, defense pleas of the carrier, of course, are one, pleas of limitation. The right to receive damage shall be extinguished if an action is not brought within 2 years, reckoned from the date of arrival at the destination, or from the date on which the aircraft ought to have arrived, or from the date on which the carriage stopped. This is, however, interesting to note that this stipulation of limitation is specific to actions for recovery of damages and would not prejudice other rights under the contract, that is the carrier's claim in respect of carriage against a passenger. The carrier can plead lack of jurisdiction in this defense if an action is not brought either before the court having jurisdiction where the carrier is ordinarily resides, or has its principal base of business, or has an establishment by which the contract has been made, or before the court having jurisdiction at the place of death. As far as the consumer court is concerned, the territorial jurisdiction has been substantially modified in favor of a landmark judgment, a great judgment for you guys is the Airport Authority of India versus Ushben Shirish Bhai Shah of 2010. Ushaben Shirish Bhai Shah 2010. In para 60, it was discussed that the Carrier by Air Act 1972 was enacted to give effect to the Warsaw Convention as amended by the Hague Protocol. India is a signatory to the Warsaw Convention of 1999, which is an international agreement governing the liability of the air carrier in respect of international carriage of passengers, baggage, and cargo by air. The convention provides that when an accident occurring during the international carriage by air causes damage to a passenger, there is a presumption of liability of the carrier. The carrier, however, is not liable if it proves that he or his agents had taken all necessary measures to avoid the damage, or that it was impossible for them to take such measures. The convention balances the imposition of presumption of liability on the carrier by limiting his liability for each passenger to a figure. There is no limitation of liability if the damage is caused by willful misconduct of the carrier or by such default on his part as, in accordance with the law of the court, sees the case is equivalent to willful misconduct. Then comes the case on air carrier liability. A great judgment is of 28th of August 2003, which is Whitma versus Martinez. By BPMA versus Martinez. MARTINAIR. In this case, the passenger Whitma suffered injury when another passenger, while trying to put the hand baggage in the overhead storage bin, drops a suitcase on the head, back of the neck and shoulder of Whitma. Whitma, that the pain ensued Martinez for sufferings that he suffered. Now, the court referred to Article 17 of the Warsaw Convention of 1929 and said the carrier is liable for damages sustained in the event of death or wounding of passenger or for any other bodily injury suffered by a passenger if the accident which caused the damage so sustained took place on board of an aircraft or in course of any of the operations of embarking or disembarking. The court considered that the only relation between this event and the carriage by Martinez was formed by the circumstances that took place on board of the aircraft of Martinez and concluded that, considering the meaning, purpose and genesis of Article 17 of the Warsaw Convention, a causal connection needs to exist between the cause of accident and the operation of the aircraft to establish an accident as meant in Article 17 of the Convention. The court found Martinez not to be liable and held that Article 17 of the Warsaw Convention is not applicable. Then, as far as the case pertaining to air carrier liability or loss of baggage is concerned, there is another great judgment called Talamini versus Transavia, which is 8 June 2005 judgment. In this, passenger Talamini flew from Netherlands to Tenerife and his checked suitcase did not arrive at Tenerife. The suitcase was damaged and the contents lost. Talamini claimed damages from Transavia, which was a Dutch-based low-cost airline, and sought replacement of his belongings, carriage for taxi, compensation for spoiled holiday. The theft of the suitcase took place after checking the baggage, that is during the carriage from one airport to another, and therefore the court held that the application of Article 22 of the Warsaw Convention of Liability of Transavia is limited to 17 SDR per kilo. Held Article 22, sub-Article 2 of Warsaw Convention applied. Case on air carrier liability delay is Tau versus Transavia, 18 June 2011. In this, a flight from Lisbon to Amsterdam had a delay of 19 hours. The operator claimed that the delay was beyond its own powers. The consumer claimed reimbursement of the cost of alternative flight, compensation for material and immaterial damages suffered as a result of the delay, exclusion of liability under the General Convention. The court held Transavia to be liable and relied on Article 23 of the Warsaw Convention, saying any provision tending to relieve the carrier liability or to fix a lower limit than that which is laid down in this convention shall be null and void. Of any such provisions does not involve the nullity of the whole contract, which shall remain subject to the provisions of this Act. Now, the liabilities have been duly marked and changed over the years. For example, during the Warsaw and in the Warsaw Convention 1929, what was given and in the baggage loss delay of claims, what was given is very different to what is given now. And that is something that you can read. I'll give you a small example. For example, as if there's a delay in the passenger or there's a loss of baggage, you would pay under the Warsaw Convention 9.07 dollars per pound. Now there is a standard amount of 1,480. If we talk about the Warsaw Convention amended by the Montreal Protocol, then they were paying $20 per kg. So that's the kind of change that we are talking about. Now, India has recently, or not so recently, signed the Montreal Convention. In order to incorporate the convention's provisions into Indian law, the Carriage by Air Amendment Act of 2008, amending the Carriage by Air Act of 1972, was enacted by the Parliament in February 2009 and notified in March 2009. So India therefore became the 91st member of the Montreal Convention on Civil Aviation that imposes strict penalty on carriers for the death of passengers due to negligence and fixes higher insurance premium towards such air disasters. The Indian Amendment Act of 2009 covers the international carriage of passengers, baggage or cargo by airline. The convention imposes minimum liability for the death of a passenger during the flight unless the airline proves that such damage was not due to the negligence or other wrongful act or omissions by the carrier. To avoid additional damages, the airline will also have the power to prove, that the damage was solely due to the negligence or other act or wrongful act of a third party, the passengers or of the person claiming compensation. The carrier is also liable for damages occasioned by delay in the carriage of passengers or cargo, and in case of death or injury of passengers, the carrier shall make advance payment without delay. Now, the Montreal Convention of 1999 is the first major revision of the provisions relating to death, injury of air passengers, loss or damage to cargo or baggage since the pact agreed at Warsaw Convention of 1999. Another great judgment for your knowledge is Abdul Salam versus Union of India and National Aviation Company of India. This is of Kerala 2011, where the court interpreted Rule 21, Sub-Rule 1, and held that no fault liability or strict liability of Air India by way of minimum compensation payment for the death of a passenger is 1 lakh SDR irrespective of age, income, loss or dependency, other factors of the deceased, or otherwise applicable for determining the liability on account. However, in suppression of the last provisions, the Montreal Convention lifted the ceiling and declared the liability of the carrier is unlimited, which is under Rule of Para 36. The court observed that the law contemplates only two conditions for liability of the carrier. One, under the Article 17(1), the carrier shall be liable for damages sustained in case of death or bodily injury of passenger upon conditions only that the incident which caused the death or injury took place on board of the aircraft or in course of any of the operations or embarking or debarking. The court observed, and that was what was reiterated by Article 26. Holding a carrier liable through payment of compensation in case of death or injury to passenger acts as a method of keeping the air carriers in check. The evolution of Warsaw Convention, the most successful system for international uniform code, conceived with a vision to protect commercial aviation during its infancy. It mirrors fundamental changes in society that had taken place from the age which made the buyer beware to one of product liability, legislation on unfair contract terms, and numerous forms of consumer protection. Each and every government wherever they may be, has always extended and protected the consumer over the years. From the era where the buyer was supposed to beware, now there are strict liability regimes where the liability and the presumption is generated whenever the act or inact comes into being. Before we conclude this topic, I would quickly tell you a bit about drafting of contracts. Drafting of contracts is very interesting as far as aviation contracts is concerned. There is something called dry contract and wet contracts. When you take a plane on lease, usually this is what happens. You may take it uh, a wet contract or a dry contract. A dry contract is plain vanilla. The plane is given to you, and you run it with your own staff, pilot, air hostess. You do your fueling yourself. In a wet contract, everything is taken care of by the aviation company, the company that's provided the aircraft, and you have no responsibility. There are advantages in both. You don't have to really, if your aircraft is standing. So this is what it is all about pertaining to the topic at hand and the issues of liability. It is a general overview of the international and Indian laws. If there are any questions, I would quickly read those. I'm sorry, I have another conference. So if there's anything at all, I would love to answer that. Otherwise, we have actually encapsulated and covered most of the points that you would ever require.
Thank you, sir. But just we can wait for 5 minutes. If we get some questions, so we can take them if you want.
Not a problem. Not a problem at all. Till the time people are thinking of questions, I can give you some personal examples. Uh, you see, we were working for a national airline, and there's a very interesting thing when it comes to international contracts. The right on the machine is always of the manufacturer. So even if you do not maintain it properly in term that has been given, they can stop the flight, and that becomes that becomes a dispute, because then it becomes a question whether you have an absolute right over the machine that you purchased, or the right will always be of the manufacturer, who can control the life cycle of the machinery that you have. The other question that also came up was cannibalizing of part. For example, a company has 10 planes, and one of the planes has been grounded, and a part is required in another plane. Can you cannibalize the part of one plane and put it in another? Because as I said, that if you do not fly your aircraft also, even for 24 hours, you're substantially suffering parking charges, hangar charges, and of course loss of revenue. So that's another very interesting thing that usually only happens in aviation industry.
Okay. So I don't think anybody is having any questions.
Then we actually had a great discussion. Thank you, Vishal.
Thank you, sir. So now I would like to invite Mr. Rupam. He will present the thank you note, then we'll end this session.
Thank you.
Thank you, Anika. Am I audible?
Yes, you
Yes.
are.
Thank you. Thank you for a wonderful session, sir. I'd like to proceed with the thank you note. I take immense pleasure in rendering today's vote of thanks to Advocate Kapil Sankla, sir. On behalf of the whole organization, I thank you for connecting with us and enlightening our participants on the topic. I thank the participants who have joined us today. Thank you for your cooperation and enthusiasm. Lastly, I'd like to thank the entire team of Amicus Curiae for pulling off this event in a successful manner. Thank you everyone for joining us today. Looking forward to more such successful and insightful session with you, sir, in the near future. Thank you, sir, once again for your time today.
Thank you for calling me, Rupam. It has been an absolute pleasure as always. Namaskar. Stay safe.
Thank you, sir.
Thank you, sir. All the participants, you can now deport the class.